So it's 2:03 p.m. CET. So what we can do is just to start with the administrative matters. I'll just mute all the participants that are unmuted. Okay, so hello everyone. Welcome to Web3 Tuesdays, the first webinar series on law and Web3. So before we start, as you know, a few housekeeping matters. This session is recorded, so if you don't want to appear in video, please consider switching off your cameras, but otherwise you are more than welcome to keep your cameras on. Also, please mute yourself during the whole presentation. At the end, we will have a Q&A session, and you will be able to unmute yourself and ask all your questions to Gérardine. Also, if you have any questions on the go, you can put them in the chat or in the Q&A box, and I will then read them for you at the end of the session. So this was an administrative part. And now we pass to the much more exciting part. So today we have an honor, a pleasure to have with us Dr. Gérardine Goh Escolar. And Gérardine is the Deputy Secretary General of HCCH, which stands for the Hague Conference on Private International Law. And Gérardine is also a full professor with the National University of Singapore. At the HCCH, Gérardine heads the International Commercial, Digital and Financial Division, and this division does a lot of very exciting projects, and I hope probably Gérardine will tell us more about that. And Gérardine also has an extensive counsel and arbitrator experience, and she has also worked for a couple of tech companies in the past in different roles. So Gérardine will tell us today about the private international law implications of the digital economy and present some of the HCCH digital projects. So Gérardine, the floor is yours.
Thank you so much, Katja, and thank you for having me. Also, thank you to Metaverse Legal. It's a pleasure to be with you here today and to have so many people online with us. As Katja's already mentioned, I work in my day job with the Hague Conference on Private or International Law, and there I head a division that we call the International Commercial, Digital and Financial Law, or Codify division. And I'd like to walk you through some of the private international law implications of the digital economy today, and then maybe through also some of the work that we're looking at the HCCH. So I'm going to try and share my screen, which as you know, then of course my computer starts to ask for a bunch of updates and all that, but hopefully you get to see this. Right, here we are. So today I want to talk to you about the private international law implications of the digital economy, and that's quite an interesting subject because what about the digital economy doesn't involve private international law? The moment it is digital, it is across a border, and the moment it is across a border, there is a private international law issue. But given the time today, what I'd like to focus on really is the specific private international law work that my organization, the HCCH, deals with, and that actually is quite an interesting thing that as I hope you will see going forward. Now, these are the things that we're talking about with private international law and the digital economy. Right in the middle, of course, we have the organization, the HCCH, and the division that's focused on this right now. We call it Codify. In the green, you see all the different aspects of the projects that we're focusing on, and I'll go through them later, slide by slide, so you can see what we're working on. But it's really exciting because we're dealing with things like digital tokens and digital assets, intellectual property, insolvency, but everything from a private international law point of view. We also cooperate with quite a few organizations in this field, and I'll walk you through the cooperation a little later. The most important thing is this: we are not going to fragment the law. What we try to do is the progressive unification of laws around the world. So we focus on the unification of private international law rules. Some of the organizations that we work with focus on the unification of other kinds of rules like private law or trade law. In the dark blue, you see the principles that we look at when we're actually looking at all these private international law issues. So we have party autonomy, access to justice, sustainable development. We look at what the choice of forum would mean when it comes to access to finance, access to credit. How do we recognize and enforce judgments across borders to give people practical access to justice? How do we look at proper connecting factors so we know what the applicable law could be? What kind of international cooperation mechanism should we focus on? And of course, in the lighter blue, you see all the different aspects and the different topics that now come up in the digital economy. So there's the big question, what general issues of private international law would arise in relation to the digital economy? And the first and easy one, of course, is applicable law and the choice of law. And there the example really is, for example, to determine the most appropriate connecting factor, defining the law applicable to, for example, an on-chain transaction. Now that used to be pretty simple. The traditional connecting factor generally was tied to a situs, for example, to a person, to some sort of identification, some sort of identifying factor that was not so difficult to find. People were generally physically located somewhere. A transaction took place at a physical location. There was a physical person. But in the digital world where everything is virtual, of course, what we're facing now is how do we locate something like that? How do we connect transactions and assets and so on to a jurisdiction? How do we tell what the applicable law will be? And this is one of the things that we look at the HCCH. Secondly, we look at jurisdiction and the choice of court. And there the example would be how to determine the competent court to resolve a dispute in relation to, for example, an on-chain asset. Which court would be competent? How would that court exercise their jurisdiction? Can parties choose which court to go through? Is there a specific set of rules when it comes to the choice of forum? How do we protect weaker parties? These are all the procedural questions that we also look at. And of course, all the lawyers on this call will know it's not much use to get to a resolution if you don't get it recognized and enforced. And so we also look at cross-border recognition and enforcement. And that, of course, the example would be to determine how a foreign judicial decision in relation to a service regulated by, for example, a smart contract would be enforced. So we're talking about 3 years in now, so we not always say a smart contract's neither smart nor a contract. But aside from that, we have basically agreements being made. And that's really as old as time, whether it's digital or whether it's physical or however it really is a decision or a certain kind of transaction that's happened. And we need other people to recognize it so that in a society with a social contract, these sorts of decisions or transactions or promises can actually be enforced. And this is also what we look at. The fourth pillar, what we do at the HCCH, deals with cross-border and now cross-platform cooperation mechanisms. And an example of that would be to determine what cooperation frameworks are feasible and desirable to overcome challenges facing the digital economy. And at the HCCH, what we do is we conduct a lot of exploratory studies to see what kinds of international cooperation mechanisms would not just be timely, but also desirable given the market movements and what the industry players need, but also feasible, meaning that because we're an international organization, the frameworks that we look at are really international treaties. So we create these treaties as conventions, principles, other kinds of instruments between countries, but the impact and the ramifications of these treaties go really right down to the human level, to the individual level, for individuals like you and me who travel across borders or conduct our business across borders. So I promised you I look at various different projects. The first one, of course, we just simply call the Digital Economy Project. And that's a pretty wide project where we are basically just monitoring across board the private international law implications of various different things. And in terms of the issues that we're monitoring, in our last meeting of our governing body, that's the Council on General Affairs and Policy, they met in March. And in March, we received a mandate to monitor the private international law implications of, in particular, these 4 fields in the digital economy. The first is the jurisdiction and applicable law in the context of securities markets. This is intermediated securities and disintermediated securities. Question: is there true disintermediation, or is all securities really just intermediated? Can we simply apply instruments we already have, like the Hague 2006 Securities Convention? Do we have to do more work on that? We also were told to look at the ramifications on technological developments on financial services and the securities industries. And what does that mean? It simply means when we're looking at things that used to be book entries, physical book entries, where there actually was a physical book, and that book no longer exists because we have a distributed ledger, what does that mean when it comes to monitoring private international law? A third topic we're looking at is guidance on applicable law in international contracts, which provide protection to weaker parties. Now, in 2015, the HCCH concluded its work on the principles on the choice of law in international commercial contracts. And just because the contract is is digital, excuse me, does not mean that these principles don't apply. I mean, these principles apply whether the contracts are digital, whether they are smart contracts. Otherwise, if it is a contract, if it is a commercial contract, if it's an international commercial contract, those principles apply. But of course, the question is, how do we protect weaker parties? Now, I'm sure some of you, all of us, I'm sure, have gone onto the App Store to try and get an app. So we try to go there and we try to buy this app that's a cool new game or a cool new camera or a new filter, a new social media platform that we want to download into our mobile devices. So you go there and you have this huge legalese that some lawyer wrote, right? And you scroll all the way to the bottom. And if you do not click accept, you cannot download that app, meaning that most of the time these days, these digital platforms have a certain set of rules, a certain set of contractual provisions that if you do not accept, you can't do business with them. So how to protect parties in those kinds of situations when the bargaining strength really is quite different between the two parties? And of course, lastly, we also look at developments related to artificial intelligence, digital platforms, and automated contracting. And that we do with our sister organization, UNCITRAL, the United Nations Commission on International Trade Law. They have Working Group 4, which has focused for many years on electronic commerce. And we actively participate in that working group. And secretary to secretary, we do deal with UNCITRAL and our colleagues there very often, specifically in relation to digital platforms and data transactions. Now, this is our flagship project. In March, we received a mandate for central bank digital currencies and the private international law implications of this. Right now, we're in the first phase of this study, and this is an exploration, really, a scoping study on what CBDCs would mean in terms of private international law. Now, remember, we do not touch regulatory matters. We really only touch on private law, private international law issues. So here, there are three big questions, of course. Applicable law. In a cross-border circulation of CBDCs, what law would be applicable? Jurisdiction, which court would have jurisdiction in relation to intermediaries? And recognition and enforcement, how will judgments in CBDC systems be recognized and enforced in different jurisdictions? Now, we use digital currencies and not simply as assets. It means that the trade in these currencies goes beyond barter. So it's not a matter of me swapping my iPhone for your new car. That's a good trade for me, I would say. But it's a matter of really using the system as a currency, and then what kind of private international law issues would arise in that context. The second one also just took place very recently. So you're actually the first public audience we're speaking to about this. We have a very close cooperation with our sister organization, UNIDROIT, the International Institute for the Unification of Private Law, that is sat in Rome. And for the first time, and this is quite momentous, the HCCH and UNIDROIT are embarking on a joint institutional project. We call it Digital Assets and Tokens Joint Project. Now, this is quite special. For the last 3 years, UNIDROIT has been doing fantastic work, and they have just concluded work on the principles, the UNIDROIT principles on digital assets and private law. Now, this is a set of principles that a group of experts have been drafting over the last 3 years. The HCCH has participated as observer in this working group, and this purports to give an overall view of private law as they would apply to digital assets and tokens, as defined by those principles. On the 12th of May, so we're talking about, 11 days ago, the Governing Council of UNIDROIT approved those principles. And so that set of principles has been finalized and approved. And please, if you have some time, have a look at it. These are a wonderful set of principles. Now, in the 19 principles in there, there's one principle 5 that deals with applicable law. And the HCCH has been dealing very closely with UNIDROIT in the last year to talk about this applicable law and what law will be applicable to digital assets. In the UNIDROIT principles is a very innovative and novel waterfall concept, which lists a certain number of sets of criteria by which you could come to what would be the applicable law. And between the secretariats, UNIDROIT and the Permanent Bureau of the HCCH had come together with a joint proposal to both our governing councils to further explore applicable law matters when it comes to the cross-border holdings and transactions in digital assets and tokens. Our governing body approved that joint project in March, and on the 12th of May, UNIDROIT's governing council also approved the joint study. So now we have the mandate between two organizations to go forward to do a scoping exploratory study. And these are the 4 issues that we will be looking at: the applicable law in the absence of an explicit choice of law by the parties, weaker party protection, and connecting factors that would impact on the law applicable to such cross-border holdings and transfers, as well as the law applicable to linked assets. Since last September, we have a new class of tokens. We call them soul-bound tokens, so really reputational assets, community-bound tokens. And of course, these sort of tokens do have some sort of connecting factor and some sort of motivation for parties to be identified. So the question would be, would the connecting factors work in this specific kind of scenario? Do we go back to the traditional private international law aspects? We're now scoping to see what would happen. So those are the 2 flagship projects that we're very proud of and very excited to embark on. We also do work in insolvency. There is a monitoring the developments in the matter of private international law and insolvency, keeping in mind that UNCITRAL also does work in Working Group 5 on insolvency matters. So UNCITRAL now is really looking at civil asset tracing and applicable law matters. But in our project, we monitor developments together with UNCITRAL in close cooperation on various different topics. Last year in September, we held a conference, the inaugural Codify conference. And there, of course, if you kind of look at the timeline, September last year, quite a few of these exchanges started to vary quite a lot in terms of how much these assets were worth. Some of them did unfortunately go insolvent. And our experts that came to that colloquium told us that these were the interesting issues that private international law-wise would be timely and desirable to study. These include the qualification, so the characterization of the digital asset, and what applicable law would be the one chosen for insolvency proceedings. Whether insolvency involving DLT and crypto assets should be addressed with ordinary rules or with specialized guidance, as well as some other questions, in particular the recognition and enforcement across borders of insolvency resolution decisions. No one talks about the digital economy without speaking about intellectual property. Now, WIPO, of course, works a lot in this field, and we work closely with them too. We only monitor developments and study in various different specific fields, and there in particular, big data, artificial intelligence, and non-fungible tokens. Specifically, we look at characterization, the law applicable, and in particular, the cross-border differences in relation to, for example, AI-generated inventions. Now, this one's quite exciting, decentralized autonomous organizations. And here we have a specific mandate to do further studies about whether regulated DAOs can be recognized in other states and whether they are actually trusts or some sort of foundation. And if so, does the HCCH 1985 Trust Convention actually apply? We also look at whether Maverick DAOs have legal existence in various jurisdictions and what law would be applicable. And we look at the existing instruments we already have to see whether DAOs would comply with securities laws and what further work can be done on them. So I'm going to stop there in view of the time. But that's my contact details. I think Katja knows that I'm probably too much on social media. So if you're on LinkedIn, I probably will see your message before your email. But do keep in contact. If you have any questions that I couldn't answer today, I'd be very happy to take those questions, of course. So I'm going to exit and hopefully stop sharing.
Thank you very much for this, Geraldine. It was very complete. We have received quite a few questions in the chat, so I will read them. But then
Sure.
if anyone wants to ask any other questions in person.
Katja, I think you have a problem with your microphone. I cannot hear you anymore.
And does it work now?
It does work now. Yes, you're good to go.
Oh, okay, thank you so much. So the first question is, once it is private law, we respect freedom to contract in pacta sunt servanda. Is it right? So I imagine that the question was about the fate of the pacta sunt servanda principle in Web3, and especially what in light of what you were saying concerning the weaker parties.
Yes, the short answer is yes. When it comes to private law, it is party autonomy, and the principle of party autonomy still does trump. There are certain categories we want to be quite certain of and quite careful of. Public policy is one of them. The protection of weaker parties is the other. So the question is, when you do have pacta sunt servanda, was it true consent? Was the party in the actual position to actually consent to whatever agreement was made? And we move from there, essentially. So yes, party autonomy is what we're working from. I think, was there a second question secondarily about the source of the law? So here's the special thing about private international law. It builds bridges, right? So we have different jurisdictions across the world, and each of the jurisdictions are almost like a little black ball. So the domestic law would apply. And private international law does not intervene in the sovereignty of that kind of domestic system. It just builds the bridge between the two systems so you know which foot should go where, essentially. So the source of the law would be the source that was chosen in that sense, if there was an applicable law. And if not, then private international provides you with the rules as to which law would be the source would apply.
Thank you very much. So the second question from Sam Johns, how do the public law and private law cooperate with each other in relation to the cryptocurrency and other digital assets?
Oh, that's a super question. That one can be a lecture of 4 hours in itself, I think. But quite quickly, within the HCCH's context, public law, if you're talking about regulatory matters, we don't touch at all. So regulation is a whole other thing, regulatory mechanisms, a whole other issue altogether. If we're talking about criminal law, we also don't touch that. So if it's really criminal perspectives on fraud, for example, we do not touch that. We really only look at private law issues. Now, how do public and private law cooperate? It's a public policy question, of course. But in particular with the HCCH, we use public international law as a mechanism to make private international law bridges so that private law works. So how does that work? We use public international law to make treaties and conventions and resolutions between countries. Those mechanisms allow us to apply private international law considerations on transactions, so we can pick applicable law, jurisdiction, and so on. And by picking those private international law rules, we allow private law, so the contract between people, tortious claims, proprietary rights, to actually be recognized and enforced across borders. So that would be how, in the abstract, it would work. It works the same in cryptocurrency as well as digital assets, except that it's harder now to pick which private international law would apply, which principles would apply, are there specialized rules or not, and that's what we're discussing right now.
Thank you. So another question is from Camila Saldias. Camila, I see you on the camera. Do you want to ask this question directly?
Okay, thank you. Well, my question is regarding digital economy is a challenge for everyone. So in this context, countries are creating divergent legal regimes. So the question is whether this context poses a challenge for the relation between applicable law and qualification, which are two basic institutions for private international law, and mostly they are relevant for the domestic judge that needs to apply the law. So that's the question.
Super, muchísimas gracias. When you're talking about those issues, basically, you are absolutely right that the basic question for private international law is a characterization matter. So when we're looking at digital assets, are they property? Are they contract? I mean, what are we talking about? Because then a different set of rules would apply. Now, if you look at a lot of the work that's been done, quite a lot of work tries to avoid the situation altogether. So they don't try to characterize, right? And one of the reasons for that is because the characterization of these things differ from jurisdiction to jurisdiction. So some jurisdictions look at certain kinds of crypto assets and say that's property. Some of them look at it and go, no, just a contract. It's not, there's no proprietary interest in there. So yes, we do have to look at it. We'll have to see what the experts tell us this year. And one of the really exciting challenges about private international law is that you're going to get experts from various different kinds of jurisdictions, civil law, common law, Islamic law, in hybrid situations, and they're going to look at it and going to tell us what can they accept so that we can build that bridge between the 2 or 3 jurisdictions. And characterization will be one of the first few things we probably will need to look at.
Thank you very much. So the next question is from Team PB. What would you say to those who say that lawyers will kill Web3?
Oof. No, I bark, I don't bite. So I think it's kind of a lot of people have said that lawyers are going to kill Web3 because, of course, Web3, the idea that you create, right? So you don't just use, you're not just an active participant, you are actually creating. And lawyers will kill that. I think really, look, in every situation, you're going to get people who want to kill things and want to build things. But I have never found a community, besides one other community which I absolutely adore and also I'm very active with, which is Space. actually no, environment as well. Lawyers in general are wonderful. They don't kill Web3. I mean, like what they do is they protect innovation, they protect all this, and they, of course, you have people, you're going to have the rotten apple at the bottom of the barrel who are going to kind of rotten us all. But the fact is, without the law, without the framework, it would be difficult. So yes, we do have Web3, which is to create and to make sure that there's not this question of too over regulation. But the question basically is, can we do without any regulation? And if we do have a situation without any regulation, then maybe we have lawyered ourselves out of a job. That's fine too. But then we know that the system works. Now, I'll tell you something that's quite interesting to me about this. Some of the people actually online, I just saw earlier, know me in person. And you know that I'm a recovering public international lawyer. So private international law is something that I came to a little later in life. Now, public international law is something special, right? So you have like basic human rights and you have all of these very kind of public interests in what's going to this. What's private law do? And I think like it's all dollars and cents and it's not really all that interesting. No, what private international law does is that it allows cross-border flows of capital, credit, and finance. And what does that do? It achieves SDG 1. It breaks the poverty cycle. It allows capital and credit to transfer across borders. It allows people to have access. The unbanked can be banked through digital law, through all of this kind of digitalization. Technology in itself is never good or bad. It's really how we use it. And I think that's wonderful about private international law. It makes it practical and real.
Thank you. So we have one last question from Dhruba. UNIDROIT principles are very much based on trust and ethics. Do you see such an environment when it comes to country jurisdictions immunity?
Well, I need a bit of clarification there. What do you mean by jurisdiction? Are you talking about jurisdictional immunity? Dhruba, if just a quick yes or no in the box would help. Are you talking about jurisdictional immunity? Otherwise, I'm going to assume. Yes, there we are. Okay. Actually, yes. I mean, like, let's put it this way. When we're talking about international law in any kind, we are talking about trust and ethics. How did this start? It used to be back in, the good old days where one sovereign would send their ambassador to another sovereign to either declare war or declare something. And if the other sovereign didn't agree, they would just send back the ambassador's head, yes? So, I mean, you kind of would go one full person and come back a half a person. I mean, that was what happened in medieval and before that. Now, what happens with international law that we have today? We have trust in the system, a system such that when we create a United Nations with 190 odd members, Vanuatu has one vote, so does the United States or China in the General Assembly. That's all based on a system of trust. That's all based on the equality, the kind of idea of the ethics of the equality of each nation state. So yes, it is based on trust and it is based on ethics. The UNIDROIT principles are also very much based on trust and ethics, but maybe at a different level, because we're really talking about actors in the digital world. And that really comes down to you and me and to everyone who wants to engage in this digitization of the world. So yes, short answer, yes, absolutely. It is an environment like this. Now, again, the caveat is we don't have a homogeneity to say across board, everyone is very trustworthy and everyone is very ethical. No, but we build towards that world, right? So it's a Wayne Gretzky thing, which I think Steve Jobs also mentioned in his 2007 iPhone sales pitch, which is you don't skate to where the puck is, you skate to where the puck will be.
Thank you, Geraldine. So our time is up. We note from the session that the lawyers are definitely need to protect the technology, and we're here to stay to protect that technology. And thank you very much for being here with us. Thank you so much for all this food for thought. We definitely look forward to seeing how all this saga with the private international law and the digital economy will evolve in the next years.
Thank you so much. Keep your fingers crossed for us. I think we have exciting work ahead. And thank you so much for having me and for this wonderful initiative. You're doing brilliant work, and I'm delighted to have been with you. So thank you for also spending part of your afternoon with me.
Thank you very much. Have a good day, everyone.
Thank you. Goodbye now.